Hi.
Hi, I'm so glad you could make it.
Oh, I'm glad we can do this. I'm really excited about this property.
Let's just go into my office.
All right.
Now that you've decided on that property, let's prepare an offer.
That simple sentence, of course, is one of the most satisfying you'll ever hear in real estate. Now, you'll have to add something to it because of new federal money laundering and anti-terrorist financing requirements. Under the old regulations, a real estate agent only had to report suspicious or large cash transactions, ones they thought might involve money laundering or transactions where more than $10,000 in cash was involved. With these new regulations, there is information to collect and forms to be completed.
Now, I have to tell you that there's a new form that I have to fill out. It's required to comply with the new federal money laundering laws and regulations.
And what form is that?
In order to comply, I have to complete what's known as an individual identification information record. Basically, it's a report showing that I verified your personal identification or ID.
Oh, really? Now, what happens to that information?
Again, this is separate from the actual real estate forms that are required. This form is required by federal law. Our broker office will have to keep it on file for the next 5 years, and if FINTRAC wants to see it, our office has to provide it.
Now, who or what is FINTRAC?
FINTRAC is the federal agency responsible for money laundering and anti-terrorist financing compliance in Canada. I have this brochure for you that explains what FINTRAC is, and it also explains why we now have to collect this information.
Before, each broker office had to have a compliance policy or regime and have a compliance officer. You had to verify that clients were not on the known terrorist list. You had to report all large cash and suspicious transactions to FINTRAC. Large cash meant $10,000 or more. With the new regulations, you have to do all of those things and more. You now have to keep a receipt of funds record for all transactions. You have to identify your client in the transaction and keep that record on file. The agent representing the buyer has to identify who provided the deposit. You have to keep all related records if a third party is involved, or if you never meet your client face-to-face. All of these records have to be kept by the brokerage for 5 years. And every 2 years, the broker has to complete a self-assessment of risk and take action to correct any problems identified by that assessment.
Just so it's clear what federal law requires me to do, I have to identify you as my client. I have to record your deposit, and I have to keep that information on file for 5 years in case FINTRAC ever wants to see it. Other than those FINTRAC requirements, our brokerage policy states that the information is confidential and is not provided to anyone else. You okay with that? Good. Then let's get started.
The identification your client provides does not have to include a photo, but there is a list of what's acceptable for verification and what's not. The list is included in the individual client information record. For example, it can be a birth certificate or driver's license, a passport, a permanent resident card, or other identification material issued by the provinces or territories. Check the list of approved identification documentation on the individual form.
The driver's license is perfect, thank you. It has all of the identification information that I need.
The identification requirement is different if you never see your buyer face-to-face or if your client indicates they're representing a third party.
One of the questions I have to ask in order to comply with federal money laundering requirements is whether you're representing anyone else in this real estate transaction. Is there another individual involved, a third party, or are you representing a company or other entity?
No, it's just myself.
Great.
FINTRAC defines a third-party situation as one where the client is acting on someone else's instructions, or if a third party is providing the deposit. This can be an individual or corporation or entity. If the client's answer is yes, you must verify identification details of the third party and record it all using the verification record for third parties, that is Part B or C of the Identification Information Form. If you can't clearly determine if a third party is or is not involved, you should also record that fact. If you never meet your client face-to-face, you must also take steps to get their identification verified. One recommended method is to use an agent or representative to meet the client wherever they live or work and collect the identification information on your behalf. Your brokerage must have a formal contract with the agent being used.
That's right. I need the identification information for George Smith, since he's buying the property. Yes, and I need the identification done based on the professional service contract we signed. I'm hoping to get the information by Monday. Is that possible?
If your client is in Canada but you never meet face-to-face, there are several other options available to meet the identification requirements. The simplest is to use an agent under contract, just as you would with a foreign buyer. If you don't do that, then you have to use 2 of 5 identification methods approved by FINTRAC.
Mr. Reed, you're acting on behalf of a company in this offer, so there are some additional reports I'm going to have to fill out and information I'll need from you. For starters, I'll need whatever documentation you have showing you have a mandate to execute an offer on behalf of the company. Again, this is all required to comply with new federal money laundering regulations. Thank you.
Under the new compliance requirements, realtors have to confirm the existence of every entity or corporation that is involved in a transaction and providing funds. You also have to confirm the identity of the individual signing on behalf of those entities or corporations. And you have to ask for a copy of the documents that give your client the authorization to represent the corporation or entity. One way to get this information is to contact your client's lawyer. If a corporation or other entity is involved, you have to complete the required parts of the client information form and take other steps to confirm representation. You have to confirm the name and address and the names and directors of every corporation involved. To confirm the existence of a corporation as well as address, you must refer to the corporation's certification of corporate status, an annual report required by provincial securities rules, or any other record that confirms the fact the corporate entity does exist.
I understand that you as a real estate agent may have to collect this information, but I'm not an agent. I'm doing this privately. So I'm sorry, but I think any of the information that you need is already available in the real estate forms that I'm already required to sign.
One of the exceptions in the new identification compliance rules involves private buyers and sellers. If you're involved in a transaction where the other party is a private buyer or seller, it becomes your responsibility to take all reasonable measures to collect the required identification information. If the private buyer or seller refuses, you have to note on the record that you attempted to get the information but were refused. You don't have to walk away from the deal, but you also have to report the reason the individual gave for not providing the identification documentation. You may also have to file a suspicious transaction report.
I don't need any more information from you for this next form that I have to complete, but I have to keep a record about the deposit you're making with your offer. This is also kept on file at our brokerage for 5 years.
This is the receipt of funds record. It's the buyer's agent who has to complete it, even if the deposit ends up directly in the bank account of the listing broker. Remember, the only time you don't have to fill out this form is if the funds are coming on behalf of a financial entity such as a bank, or from a government agency, or if a large cash transaction record is required instead.
Well, that's it, Mr. Reed. I have all the information and documentation I need to comply with the new money laundering and anti-terrorist financing regulations. Thank you for your patience and understanding. Here you go.
So to summarize some important points, here are a few housekeeping rules. The official copy of all reports of forms required for FINTRAC compliance must be kept in the brokerage, or the files have to clearly indicate where it is being stored. Wherever they are stored, make sure it is secure. Brokers are responsible for the privacy and security of the personal information collected in this process. Records must be kept for 5 years from the date they were created. They can be in a machine-readable or electronic format as long as a paper copy can be produced upon request. When FINTRAC asks, you have 30 calendar days to produce the documents. Remember, these additional training and information resources are available to you at any time on RealtorLink.